Please be seated. The sitting is open. I'd like to note that the following judges are present with me in the Great Hall of Justice: Vice President Gevorgian and Judges Tomka, Yusuf, Shway, Sebutinde, Iwasawa, and Charlesworth, while Judges Abraham, Benuna, Bandari, Robinson, Salam and Nolte, and Judges Ad hoc Dode and Zima are participating by video link. The court meets this afternoon to hear Chile's second round of oral argument on its own claims. I shall now give the floor to Mr. Samuel Wordsworth. You have the floor.
Madam President, members of the court, I'll be taking stock of the key issues as they now stand at the beginning of this, the second round, before coming back to the facts on ground and surface water flows, including the two facts, as identified in opening, that matter for the court's determination on the key issues. In terms of taking stock, there are two critical points to take from the first round. First, there is Bolivia's decision to retreat from the case in its written pleadings on sovereignty over the so-called artificial flows allegedly generated by the channels constructed in Bolivian territory pursuant to the express permission of Bolivia. Professor McCaffrey took you through the details last Wednesday, and I'll not repeat them now. But in brief, up to last week, Bolivia was claiming that it had exclusive sovereignty over the so-called artificial flows, such that any use thereof depended on Bolivia's consent. And this was supported by various US cases and other materials concerning salvaged waters and the like. On this basis, Bolivia claimed that the so-called artificial flows were excluded from the customary international law rules reflected in the 1997 Convention and subject only to Bolivia's domestic law. That case was none too subtly jettisoned by Mr. Bundy last week, and it's now said that there is only sovereignty over the so-called artificial flows in the sense that it is for Bolivia alone to decide whether or not to dismantle the channels on its territory. Chile, of course, has no objection to Bolivia abandoning the central legal underpinnings of its defence and counterclaims. But the important point for now is that Bolivia has not abandoned its case that the so-called artificial flows are to be distinguished from natural flows and hence are to be accorded some form of different legal treatment. The difference in Bolivia's case is that this erroneous proposition is now supported merely by adjectives, assertions that the Silala is unique, particular and exceptional, as opposed to any legal principle, however misconceived. So while the legal arguments that the court needs to decide have been reduced, there has been no reduction in the number of issues in dispute. Second, aware that it cannot articulate before you any tenable legal basis for its case on artificial flows, Bolivia has introduced various tortuous arguments as to the nature or existence or prematurity of a dispute, with the aim of making the case go away, or at least showing that it's been acting reasonably, and it has asserted that there are shades of ambiguity in Chile's position, when in reality there are none. The underlying desire on Bolivia's part is no doubt that the court should do as little as possible and send these two states away as if they were two children in a playground who just need to be told that they must cooperate. Yet the dispute is real. It is now before the court, and there are real issues to be determined as between two states that have not enjoyed diplomatic relations since these were cut off by Bolivia in 1978. In particular, the court must determine whether the Silala in its entirety is an international watercourse, subject to the rules of international law reflected in the 1997 UN Convention, and whether Chile is entitled to its current use of the waters of the Salala. It is the determination of these two issues that will settle the dispute reflected in the first three heads of relief sought by each party, as well as Bolivia's counterclaims 2 and 3. Now, turning in a little more detail to the issues on the dispute, as presented by Bolivia in its opening last week, Professor Forto's curious position was that there is in fact no dispute between the parties, or that the dispute is without object. Yet the dispute is manifest. Chile, in its first request for relief, seeks a declaration that the Salala River system, together with the subterranean portions of its system, is an international watercourse, the use of which is governed by customary international law. Certainly, Bolivia has belatedly accepted that this is true to an extent, but there has been no retraction from the submissions to Bolivia's counter-memorial, where it is claimed that the waters of the Salala Springs are part of an artificially enhanced watercourse, and customary international rules on the use of international watercourses do not apply to the artificially flowing Salala waters. The fundamental point of disagreement reflected in those competing submissions then follows through into the parties' competing submissions on equitable and reasonable utilisation. Whereas Chile claims that it is entitled to the equitable and reasonable utilisation of the waters of the Salala system in accordance with customary international law, Bolivia seeks a declaration confining the application of this principle to the parties' entitlement in respect of so-called naturally flowing Salala waters, in contradistinction, of course, to the so-called artificially flowing waters of the Salala. There are then, of course, other issues in dispute, including as to the interpretation to be given to equitable and reasonable utilisation and to the exchange of information and notification obligations. The fact that Chile does not object and has never objected to Bolivia removing the channels, the construction of which Bolivia has permitted on its territory, does not somehow negate the existence of the key dispute as to the law and legal principles that apply to the Salala. At most, that fact reinforces the point that Bolivia's position is plainly untenable. It is a nonsense to say that an upstream state can unilaterally elect to drain groundwater that would anyway flow to the downstream state and thereby qualify that water for some special and more favourable legal treatment. It is all the more of a nonsense when the downstream state is saying that the drains can be removed as and when the upstream state wishes. With respect, I fear Professor Forto is confusing two quite discrete matters. The absence of a tenable defence on Bolivia's part does not translate into the absence of a dispute. In short, it was very puzzling to hear the submission by reference to Marshall Islands and the United Kingdom that there are no clearly opposed or irreconcilable views in this case. attempt on Bolivia's part to mischaracterize Chile's claim as being to an acquired right and to an entitlement to crystallize the status quo. All this in circumstances where Chile has been at pains to make clear that it is not seeking to restrict any future uses of Bolivia or impinge in any way on a decision on Bolivia's part to remove the channels in its wetlands. There are three further points to respond to on the court's mandate to adjudge the current dispute. First, the argument was made that the dispute was premature. This was a brave submission in light of the fact that in 2002, Bolivia itself was publicly considering cutting off the flow, or, as an alternative, that a dispute be taken to this court or to international arbitration. And no less brave in light of the fact that Bolivia itself announced that it was bringing the dispute to this court in 2016. Second, Professor Forto contended that the court could not make declarations on purely hypothetical matters, and in this respect emphasised the absence of any act by Bolivia to interfere with the flows of the Silala. Well, the absence of what would be an obvious breach of international law is very welcome, but it does not somehow engage the court's jurisprudence stemming from the Northern Cameroons case on the need for its judgments to have, I quote, some practical consequence in the sense that they can affect existing legal rights or obligations of the parties, thus removing uncertainty from their legal relations. That is precisely the practical consequence that Chile seeks in this case. And this, of course, is not a case like Northern Cameroons or the interim accord case to which Professor Forto was referring, where Greece argued that a determination would be devoid of any effect because the court's judgment would not be able to annul or amend NATO's decision on admission of the then former Yugoslav Republic of Macedonia. There is nothing remotely equivalent in the current case, and it is anyway to be recalled that the court rejected Greece's argument, holding that a judgment of the court in the present case would not be without object because it would affect existing rights and obligations of the parties under the interim accord and would be capable of being applied effectively by them. Well, just so here. Third, Professor Forto also referred to the passage in Burkina Faso, Niger, where the court was considering its powers to record, in the operative part of a judgment, an agreement arrived at between the parties before the proceedings were instituted. It distinguished this situation from previous cases whereby agreements were reached during the proceedings and the court took them into account. It was as if, in a parallel universe, when in 2019 Chile did indeed seek an evidently reasonable and balanced settlement of this case after receipt of Bolivia's rejoinder, Bolivia had taken the trouble to respond, but it did not. The agent for Chile will have a little more to say on the details of the proposed agreement of 2019 later today, but the point for now is that there was no agreement reached, and the relevance of Burkina Faso, Niger, is, to say the least, unclear. I move to the issues of fact relevant to the court's key determinations. To recall, there are only two facts relevant to the court's determinations on the surface and groundwaters of the Silala River. The first round, including the cross-examination of the experts, has served to confirm that these two facts are common ground. To recap, fact one. As Bolivia accepted last week, the construction of the channels on Bolivian territory said to generate the so-called artificial surface water flows and to have led to a deterioration in the Bolivian wetlands were constructed by FCAB, an English company, pursuant to the 1908 licence granted by Bolivia. And however much Bolivia focuses on alleged degradation of the wetlands in its territory, it remains the case that this is degradation for which Bolivia alone could be responsible. Likewise, Bolivia's unilateral decisions cannot somehow impact on the status of the Salala or curtail the nature or content of Chile's rights under the customary rules reflected in the 1997 Convention. This remains the case regardless of how Bolivia may seek to fit into its legal arguments its unilateral licensing of the construction and its retention since 1997 of the channels. That is, whether this is under the guise of some alleged exceptionality or somehow shoehorned into a case on equitable and reasonable utilisation. Fact 2. As all experts agree, the Salala is a coupled surface and groundwater system, and whether as surface water or groundwater, all the water will eventually flow to Chile. In the words of DHI's Mr. Jensen last Friday, the total amount of flow going from Bolivia into Chile with and without the canals, groundwater and surface water will not change. It follows from the expert agreement that the Salala is an international watercourse in its entirety, and as Bolivia has now accepted, that it cannot tenably be argued that an upstream state has exclusive sovereign rights over alleged artificial flows that would anyway have reached the downstream state as groundwater. Of course, the Court has now heard from the experts on their areas of disagreement, and although in no way critical to the Court's reasoning, we do invite the Court to note 7 short points. First, it was remarkable quite how many times last week Bolivia sought to rely on the 131 litres per second flow measurement taken by the FCAB's Mr. Fox in or around 1922, at a point we now know as point C7, and one suspects that he would have been more than a little surprised by this moment of posthumous fame. Yet while DHI has compared this to a figure of 160 litres per second in its reports, Mr. Jensen had to accept last Friday that the series of simultaneous manual measurements taken by Bolivia's tsunami in 2017 to 2018 show flows that are consistent with, and in certain cases identical to, Mr. Fox. One can see that not least from DHI's own figure 17, which reveals an average of 131 litres per second measured at this point C7 by Bolivia's own Water Services Institute. Now, Mr. Bundy suggested in re-examination on Friday that Mr. Jensen had been taken to a number of selected measurements from a 2017 and 2018 period at C7, and that is quite wrong. He was taken to the entirety of the so-called simultaneous measurements taken by tsunami during its measurement programme of 2017 to 2018, so far as we were able to find these in Bolivia's annexes. Mr. Bundy also referred to Table 7 in Annex G to DHI's 2018 report, which states the measured flow for C7 as being 154 litres per second. But this has been arrived at merely by adding the sum of 2 flow measurements from points upstream, whilst for some reason ignoring the actual manually measured flows at C7, which are in the region of 131 litres per second. And for completeness, insofar as Bolivia wishes to rely on Chile's cross-border flow figure of 170 litres per second, you will recall it kept repeating that last week, the obvious point is that this is taken from a point more than 650 metres downstream from Bolivia's point C7. It is anyway just an average of measurements which range from 130 to 230 litres per second. So, as was put to Mr. Jensen on Friday, there are only two relevant possibilities. Either the 2017-2018 tsunami manual measurements and the Fox measurements are correct, both being at or around 131 litres per second, so that there has been no change over the 100 years, or the 2017-2018 tsunami manual measurements taken with modern equipment are wrong, in which case there is no conceivable basis on which it could be said that Mr. Fox, taking measurements 100 years ago with unknown methods, can somehow be taken as correct. The court will recall that Mr. Jensen's position was that both Mr. Fox and Tsunami's manual measurements were correct. You can see that at the bottom on your screens. You see the question, and do you agree then that Mr. Fox is correct, and therefore one can take these figures as correct also? And the answer from Mr. Jensen, I believe these are also correct, but not because Mr. Fox is correct. Even had he thought otherwise, it wouldn't have mattered. The simple point is that by reference to Bolivia's own manual measurements of 2017 to 2018, Mr. Fox's measurements support the conclusions of Chile's experts that the channels have not led to a material change in flow. My second point. Great weight was placed in Mr. Bundy's cross-examination of Dr. Wheater on the fact that Chile's experts had not undertaken field studies in Bolivia, and reference was made to their failure to walk a few metres or a few hundred metres across the border, which Bolivia would apparently have agreed to. Yet one only needs to look at the extent of the work done by Chile's experts on the Chilean side: the drilling of 8 boreholes, installation of 164 wetland piezometers, detailed spring surveys at over 30 sites, and so on, to see that this is wholly unrealistic to assert that the two states would have been able to agree to Chile's experts conducting a meaningful exercise on Bolivian territory, whereas, as Dr. Wheater explained, Chile had the benefit of the field work carried out by Bolivia's experts. Third, as to the DHI model, while the revised estimates put forward by DHI with Bolivia's reply are in the notably broad range of 11 to 33%, Mr. Jensen gave two contradictory answers on Friday to Judge Tomka and to the President as to what that range represents. It now appears that it does not represent a range at all, but rather the outcome of modelling two different scenarios, the so-called no-canal scenario and a restored scenario where peat has grown back at some unknown date in the future. Consistent with what Mr. Jensen said, this is indeed not clear from the DHI reports, which go on repeatedly about their having carried out a sensitivity analysis to get to the 11 to 33% range, whereas in fact it now appears that these two figures just represent the modelling of two entirely different scenarios. This could scarcely be a more basic matter, and yet we are left confused as to what the DHI figures are actually intended to represent. Fourth, the court will recall that Chile had to request and then insist on the provision of the digital data that DHI had used in its models, Bolivia having initially refused to provide the data. And the data once supplied showed that there had been various unexplained and unreported additions of water to DHI's modelling. The difficulty here is not just the failure to report and explain. Rather, all experts agree that the springs are entirely fed by groundwater. Thus, if the model that DHI has created were functioning correctly, all water would enter the near field as groundwater across the model boundary. There should be no need for the artificial addition of any water into the model. The DHI felt the need to add an unreported 42 litres per second to the surface water in the baseline scenario, completely bypassing the groundwater and surface water interactions they were modelling, is evidence that their modelling had gone wrong and was not doing what it was supposed to do. The same basic point applies to the unreported additional 10 litres per second of water the DHI has added selectively to the simulated results. Mr. Jacobson suggested that this was to compensate for the difference in the 42 and 31 litres per second that DHI also adds, but that cannot be right. The additional 10 litres per second has been added directly to the results. It was not added as an input into the model. And if DHI considered that an error had been made, the proper thing to do was to rerun the model to get correct results, and not to add arbitrary and unexplained amounts of water to the results the model had already produced. Fifth, in answer to a question put by Judge Tomka on an unrelated matter, Mr. Jensen suddenly volunteered that the calculations on which Dr. Wheater was cross-examined last Thursday did not show the effects of the channels, but was instead a pure groundwater simulation that compares the level changes of the canals compared to the total water level difference in the catchment. And one wonders why the point was not put to Dr. Wheater. And one might also wonder whether one of the world's leading hydrologists is really prone to making simple errors. But put simply, Dr. Jensen's point is wrong. Dr. Wheater's simplified analysis assumes all groundwater discharges to the river system, showing the effects on river flows of a reduction of the wetland table by ½ a metre due to the channels, and an additional 1 metre layer of peat. And the Wheater and Peach calculation does indeed show that the impacts are negligible. Sixth, in any realistic modelling of a situation where the channels only reduce the groundwater table by 10 to 45 centimetres, the inputs would be the same, regardless of the scenario being modelled. The groundwater coming into the wetlands cannot magically increase depending on what given scenario is being modelled. Yet, when one looks at DHI's Table 1 in its 2018 report, that is precisely what is happening. Compare the inflow figure of 253 litres per second for the baseline scenario with the 221 and 216 figures for the other scenarios. So the inflow into the baseline is much higher. And surprise, surprise, one might think, the modelled output is much higher too. DHI has sought to explain this anomaly by saying that some of the groundwater in the baseline could go other than through the modelled area. Chile's experts have explained that this cannot be correct and is based on a misunderstanding of the geology of the near-field area. And on Friday, on the issue of whether water could find its way around the modelled area, Mr. Jensen stated that we do not say this is correct. Although most puzzlingly, he went on to suggest that DHI was giving a conservative estimate on the safe side. Finally, while any ecological degradation that may be caused by works that Bolivia has licensed is a matter for Bolivia, Chile has made plain that it encourages Bolivia to restore the Silala wetlands, and time and again has emphasised that it could not complain about any drop in water flows or quality caused by dismantling the channels, assuming, of course, Bolivia complies with its international law obligations. Chile also recognises that the Silala wetland is part, albeit a very small and hydrologically disconnected part, of the 1.4 million hectare Los Lipes Ramsar site, which you can see on the screen. On the left of the map, we have added the Silala River in blue and the Silala catchment area in green. At the same time, Chile does note that such degradation as there is may be caused by a number of factors. And were this an issue that the court had to resolve, Chile would be noting the absence of a persuasive causal link between the channelization and any degradation. Such would not be supported by the evidence as understood by Drs. Wheater and Peach, including by reference to the nearby wetland on Chile's side of the border. And Bolivia's own studies accept that wetland degradation may be attributable to natural causes as well as man-made impacts like channel construction. It may also be noted that the two reports by the Bolivian Foundation for the Development of Ecology state that wetland degradation began around 1908. That is 20 years before the channels were constructed. In short, as Dr. Wheater explained in answer to a question from Judge Tomka, there is no clear-cut evidence, in my opinion, to link the channels with the degradation. But that does not mean to say that there is no degradation. What it does mean is that if Bolivia wishes to restore the wetlands, they really need to take care and take account of all the factors, particularly climate variability. We've seen from our satellite imagery the seasonal change and the interannual change in wetland extent, depending on a seasonal precipitation. Madam President, members of the Court does not need to go deep into the areas of disagreement between the experts. But to the extent it does so, the evidence of Drs. Wheater and Peach is plainly to be preferred. Madam President, members of the Court, that concludes my submissions. I thank you for your attention and ask you to hand the floor to Dr. Klein-Kranenberg.
I thank Mr. Wordsworth for his statement, and I now invite the next speaker, Ms. Johanna Klein-Kranenberg, to take the floor. You have the floor, Madam.
Madam President, distinguished members of the Court, it is an honor to appear before you again on behalf of the Republic of Chile. Last week, I showed you that the channels in Bolivia were executed by an English company, FCAB, pursuant to a license granted by Bolivia in 1908, from which it followed that the channels and the alleged artificial flow are not in any way attributable to Chile. From this, it also follows that any degradation of the Silala wetlands in Bolivia, if caused by those channels, which is by no means certain, cannot in any way be attributed to Chile. Chile has confirmed, and Bolivia agrees, that it is entirely within Bolivia's sovereign powers to dismantle the channels and to restore the wetlands in its territory in compliance with any applicable obligations of Bolivia under the Ramsar Convention and customary international law, through the best means it sees fit. This should not and can no longer be contested. Today, I will limit myself to addressing two matters on which Bolivia's Council has tried to create confusion. The first, related to the origins and content of the dispute between Bolivia and Chile, suggesting that Chile is just meddling in Bolivia's domestic affairs. And the second, related to the 2009 draft preliminary agreement, which never entered into force, but which Bolivia seems to claim has relevance for the court's decision. I will start with the origins and content of the dispute. As Mr. Wordsworth has just explained, Bolivia has tried to create the impression that there is no real dispute between both states as concerns the Silala River. Bolivia has also suggested that, instead, there is a dispute between Bolivia and a private company, FCAB, under Bolivian domestic law, related to the termination in 1997 of the 1908 Bolivian concession. That Bolivia has recognized as much in public statements of that same year, but that nevertheless Chile has put itself in the place of the FCAB, defending FCAB's interests and compelling Bolivia to maintain the channels in its territory. So that finally, really, Chile can have no real complaints against Bolivia because there are no current competing uses in its territory. All this to suggest that Chile has no genuine interest in the Silala River when it engaged the court. This version of the facts distorts reality and obliges me to set the record straight. On 8 May 1996, responding to allegations in the Bolivian press on the supposed diversion of the waters of the Silala into Chile, the then Foreign Ministry of Bolivia issued an official press release stating as follows, and I quote, "Under instructions from the Honorable Minister of Foreign Affairs of the Republic, Dr. Antonio Aganiva Quiroga, the chair of the National Commission of Sovereignty and Boundaries presented a technical report on the international nature of said river. The Silala is a river that has its origin in a spring at the foot of the hill of the same name in Bolivian territory, after which it crosses into Chilean territory." End of quote. This was, of course, entirely correct and represented Bolivia's official position at the time. No doubt catering to local pressures, the Foreign Ministry also said that it, and I quote, "will include this issue on the bilateral agenda, given that the waters of the Silala River have been used since more than a century by Chile and not by Bolivia, whereas the Bolivian state should be the beneficiary of the revenues of those waters." End of quote. As you can see, even though Bolivia appeared to see at the time that the Silala was a shared watercourse, the idea that it had a right to compensation for the uses in Chile was already taking shape. 2 weeks later, on 20 May 1996, the same Bolivian Foreign Minister, Aganivar, visited the Silala heading a delegation of diplomatic and parliamentary representatives and the Minister of Defense. He again made short shrift of the idea that the waters had been diverted through the channels into Chile, but insisted that the issue of compensation should be included in the bilateral agenda with Chile. This shows that in the mind of Bolivia, the compensation issue was not conceived as dependent on the status of the Silala as an international river, but rather as an inherent right to benefit financially from the uses of the waters in Chile. Interestingly, the supposed inherent right to benefit from the uses in Chile still has echoes in Bolivia's position as of last week, when it claimed that Chile's past use of all the waters should be taken into account to determine Bolivia's future entitlement to equitable and reasonable use. This should alert the court that, even though Bolivia now recognizes that the Silala River is an international watercourse, as far as concerns its naturally flowing waters, and would prefer the court to declare the dispute brought by Chile moot, Chile needs a decision from the court that confirms the application of the principle of reasonable and equitable use to all waters of the Silala, which does not consider any kind of right to compensation for past or future uses. Coming back to the origins of the dispute, 1 week after the visit of Foreign Minister Aganibar to the Silala River, on 28 May 1996, Chilean Vice Chancellor Mariano Fernandez was quoted in the Bolivian press as saying, while reading from the 1908 Bolivian concession and apologizing for not being an expert in hydrology, that the matter of the concession was clearly for the Bolivian government or the competent court in Bolivia to determine. He also said that the issue of an eventual compensation for the centennial use of the waters, still studied by the Bolivian Foreign Ministry, is reduced to a negotiation with the current company that holds the alleged permit, making clear that this was not a matter that concerned Chile or its relations with Bolivia. 1 year later, on 14 May 1997, the 1908 Bolivian concession was terminated, officially because FCAB no longer was using the steam engines for which the water had originally been granted. I note in passing that, according to Professor Pelé, Bolivia had never been notified of the conversion of steam engines to diesels, probably to explain Bolivia's much belated response to the change of uses of the waters of the Silala starting from the 1960s. Professor Pelé even suggested that Bolivia may not have been aware that steam engines were no longer the fashion, even though the railroad runs for approximately 700 kilometers through Bolivian territory, was nationalized in Bolivia in the late 1960s, and has at different moments in time been operated in Bolivia by Bolivia itself. You can find the 1997 termination of the 1908 Bolivian concession under Key 8 in your Key Documents folder that we handed out on the first day of the hearing. I call attention to the fact that the 1908 concession was not merely terminated, but that its adjudication was, and I quote, reversed and annulled, rendering null and void the public deed 48/1908 of 28 October 1908, and that its registration was cancelled as if it had never existed. notwithstanding the legal actions to procure compensation as deemed by law." End of quote. This must be the compensation to which Bolivia's agent, Ambassador Calzadilla, referred in his opening statement last week, Monday, which he said remains pending a solution until now. Going back to 1997, after the termination of the 1908 concession, the Chilean Vice Minister, Mariano Fernandez, confirmed that the annulment of the concession did not give rise to a dispute between Bolivia and Chile about the waters of the Silala. And it is important to keep in mind that up to then, Bolivia had never publicly stated that the Silala River is not a shared watercourse. But this position started to change in April 1999, when the Bolivian House of Deputies urged that the Bolivian Military Geographic Institute be instructed to, and I quote, "modify the maps in which the existence of an alleged river called Silala or Siloli is mistakenly portrayed, because in the area there are only water holes, streams or springs that do not constitute a permanent watercourse." And they also considered it urgent to instruct all divisions of the state to stop using the word river when referring to the Silala Springs, given that said confusion could bring serious problems to the national sovereignty. End of quote. It was to these public statements that Chile responded by sending its first note on the matter on 20 May 1999. Chile noted the erroneous statements made by the members of parliament and the Ministry of Foreign Affairs in relation to the Silala and affirmed its nature as an international and shared water resource. To this, Bolivia responded by note of 3 September 1999, from which I read extensively last week, and in which Bolivia made the point that the 1908 Bolivian concession was granted to a private company, and that, I quote, "it would be incomprehensible for Chile to want to assume responsibility for any actions undertaken under that concession." However, in that same note, Bolivia also, for the first time, referred to the artificial works that have generated a system that lacks any characteristic of a river, let alone of an international river or a successive course, thus denying in terms the Silala River's international nature as a shared watercourse. From then on, including in Chile's response by note of 15 September 1999, the discussion between Bolivia and Chile centered on the nature of the Silala River as an international watercourse, leaving aside any issues related to the termination of the 1908 Bolivian concession, which both states agreed was a matter of Bolivian domestic law. Chile also only objected to the public tender process in Bolivia in the years 1999-2000 that adjudicated the waters of the Silala to the company RTUK, to the extent that the terms of that tender disregarded the shared nature of the Silala River. At no point did Chile demand that Bolivia maintain the channels to the benefit of FCAB. As Professor Boisson de Chazoun already pointed out to you last week on Wednesday, and as Mr. Wordsworth has recalled, a 2002 exchange of press releases cited by Bolivia's counsel in this regard shows Bolivia threatening to cut off the flow of the Silala or, in the alternative, initiate legal actions against Chile, to which Chile responded by rejecting all measures that would obstruct the flow into Chile. At no point did Bolivia express its intent to dismantle the channels, and clearly Chile did not make any statements that could be interpreted as opposing such actions, which were not announced anyway. Bolivia's council has also referred to Chile's application to the court in 2016 as effectively denying Bolivia's right to dismantle the drainage system, and therefore as a response to the question that I posed last week as to why Bolivia did not dismantle the channels after 1997. That makes no sense. Chile's application did not come till almost 20 years after the concession was terminated by Bolivia, following Bolivian threats to bring Chile before this court, and anyway concerns the status of the Silala and related rights, not the existence of channels that were built upon a license granted by Bolivia on its territory. My rhetorical question, as Mr. Bundy chose to call it, remains unanswered. In short, as the true chronology shows, 1, there is a dispute between Chile and Bolivia that originated in 1999 and that is unrelated to any matters that may exist between FCAB and Bolivia under Bolivian law. 2, from the start, this dispute concerned the status of the Silala as an international watercourse, which was denied by Bolivia and affirmed by Chile. 3, as of today, there is still a dispute between Chile and Bolivia on whether the Silala River in its entirety is subject to the rules of customary international law, and whether Chile's current use is in accordance with the principle of reasonable and equitable utilization. And 4, the maintenance of the channels in Bolivia was never part of the dispute and was never requested by Chile. I will now turn to the 2009 draft preliminary agreement that never entered into force. It was notable last week that in the absence of sound legal principles to base its arguments, Bolivia placed great reliance on various drafts of a 2009 preliminary agreement that was never agreed. The principal aim appears to have been to link these 2009 drafts to the nature of Bolivia's entitlement to the reasonable and equitable use of the Silala. Mr. Bundy referred to the 2009 drafts as, and I quote, an indication of what they, Bolivia and Chile, considered equitable and reasonable at the time, end of quote. For his part, Professor Pelé referred to the 2009 draft to say that Chile had agreed to pay compensation for the use of the waters of the Silala. With respect, both Mr. Bundy and Professor Pelé are wrong. First, various draft preliminary agreements were exchanged in 2009, but none of these were finalized and concluded, and none can be relied on by the court. As the court confirmed in the nuclear test cases, referring back to the decision of the Permanent Court of International Justice in the Chorzów case, I quote, "The court cannot take into account declarations, admissions, or proposals which the parties may have made during direct negotiations between themselves when such negotiations have not led to a complete agreement." End of quote. Second, these drafts aimed at establishing an interim solution and were predicated on there being a disagreement as to the status of the Silala River. This is clear from Article 1 of the 13 November 2009 draft, which stated as follows. This initial agreement establishes the framework to work together with a view to moving forward in the convergence of the different points of view that have emerged between Chile and Bolivia over the Silala waters, considering that A, to Bolivia, the Silala waters are of its complete property and come from dozens of springs located within its territory, and the existing abstraction and canalization works are responsible for giving rise to the current surface runoff. B, to Chile, the Silala waters flow naturally across the border and constitute a successive international watercourse, to which the criteria on equitable and reasonable uses are to be applied under international law, situation in which Bolivia is an upstream state and Chile the downstream one. End of quote. Chile has not changed its position since 2009. However, Bolivia, thanks to the studies it has undertaken during the present proceedings, has evolved in its understanding of the Silala River and now recognizes that it is an international watercourse, save for the so-called artificial flow, which it appears still somehow to exempt from the rules of customary international law, otherwise applicable to international watercourses. In this, it is obviously wrong, as Professor McCaffrey pointed out in his presentation of last Wednesday. Even Bolivia itself has been reluctant to make the argument with any clarity, consistency, or force. So now that the predicament that underpinned the 2009 negotiations is no longer in place, there is nothing in the draft agreement that could be of any relevance today, even if it were somehow permissible to take account of what states put into drafts that they never finalize or agree to be bound by. Third, a key reason for the failure of the negotiations was Bolivia's demand for compensation for past uses of the Silala in Chile, the so-called historic debt. This first surfaced at the 22nd meeting of the Bolivia-Chile Political Consultations Mechanism in July 2010, and resulted in Bolivia's proposal to incorporate a reference to compensation for past use of the Silala waters in the 2009 draft preliminary agreement. Contrary to what Professor Pelé suggested in his presentation last week, Chile has never agreed to pay for the waters of the Silala, and Bolivia's historic debt claim sounded the death knell of the negotiations. As you were told by Professor Boyle, Bolivia's claim for payment is extraneous to international law and international practice. Madam President, members of the Court, I've come to the end of my presentation and I thank you for your kind attention. Madam President, I ask if you would please give the floor to Professor Laurence Boison de Chazoun. Thank you.
I thank Ms. Klein-Kronenberg, and I shall now give the floor to Professor Laurence Boison de Chazoun. You have the floor, Professor.
Madam President, distinguished members of the Court, it's a great honour for me to appear before you once again on behalf of the Republic of Chile. Chile and Bolivia both agree that the Silala is an international watercourse, but Bolivia further maintains that a portion of the waters of the Silala are allegedly artificial waters which are subject to a particular legal regime. This is something with which Chile vehemently disagrees. Regarding the applicable principles to international watercourse, the two states agree to consider that they do include equitable and reasonable utilization, the obligation to cooperate, the obligation to take all appropriate measures to prevent and limit pollution, the duty to exchange information and notification, and prior notification of planned measures, and also the obligation to carry out an environmental impact study. Other points of agreement between Chile and Bolivia should be underscored. So, the limited nature of water resources, for example, the need to sustainably manage these water resources, and the importance of protecting the environment. From this point of view, Chile rejoices at the announcement made by Bolivia regarding their decision to revitalize the bofedales, classed as wetlands of international importance under the 1971 Convention on Wetlands of International Importance, which is also called the Ramsar Convention. Now, Chile is also party to this convention and indeed has 16 registered sites of international importance. As Professor McCaffrey recalled, the assertion whereby Silala, I quote, cannot be described purely as a natural international watercourse is without consequence under international law. Customary international law applies to all waters of the Silala, and that even if Bolivia resorts to cumbersome wordplay not to admit it. Disagreement between Chile and Bolivia relate inter alia to the interpretation and application of the principle of equitable and reasonable utilization and the obligations linked to this principle in matters of exchanging information and prior notification. Chile will demonstrate that the principle of equitable and reasonable utilization can and must obtain in the instant case. Chile will underscore subsequently the links between that principle and other legal obligations pertaining to international watercourses and will recall the conditions of their application. The utilizations of the Sala's waters date back to the beginning of the 20th century, and Bolivia has never challenged Chile's use of them. And Bolivia itself used these waters during the 20th century, granting a concession to the FCAB. Be this as it may, Bolivia continues to assert that Chile is purportedly denying, I quote, Bolivia's corresponding right to an equitable and reasonable use of those waters, and is demanding, I quote again, that the situation as it stands remains immutable. Bolivia also maintains that the right to an equitable and reasonable utilization is a one-way street only for the benefit of Chile. Now, that's a quotation. And that Chile purportedly has, I quote, a permanent acquired right. Furthermore, for Bolivia, Chile's demand to have its current usage recognized as being consistent with the principle of equitable and reasonable utilization would be tantamount to recognize as, I quote, a status quo. Now, Chile has never made such claims. Chile's claim that its current use of the waters of the Silala be recognized as consistent with the principle of equitable and reasonable utilization in no way prejudices future use of the waters of the Silala by Bolivia. Chile's claim is based on the recognition of its right to an equitable and reasonable utilization of the waters of the Silala, and Chile very explicitly stated that Bolivia is an equal beneficiary of this right. Contrary to what Bolivia claims, Chile does not disregard, and I quote again, Bolivia's right to use of the waters of the Silala. On a number of occasions, Chile has underscored the application of the principle of the community of rights and interests, which is founded on the perfect equality of all riparian states in the use of the whole course of the river and the exclusion of any preferential privilege of any one riparian state in relation to the others. Both Chile and Bolivia have the right to an equitable and reasonable utilization of the Silala's waters. Chile does not seek to create an obstacle to Bolivia's future use of the waters of the Silala. Chile is indeed indicated during the oral hearings of 1 April this year that it does not seek to impede Bolivia's development and future use of the waters of Silala, as Chile had already indicated on numerous occasions in its written pleadings. So, Chile remains mystified why Bolivia still has doubts about this, unless, of course, that is a litigation strategy. Madam President, distinguished members of the Court, Chile requests that its right to an equitable and reasonable utilization of the Silala's waters be recognized. Unlike what Bolivia asserts, this recognition is based neither on, I quote, the rigid equation, equitable utilization equals status quo, nor on the claim to, I quote, an acquired right to continue enjoying the waters of the Silala that it currently enjoys. These assertions mischaracterize Chile's position. Bolivia, moreover, has itself recognized that it takes note that Chile has stated that it is not requesting, I'm quoting here, not requesting the court to prejudge what an equitable and reasonable utilization of the Silala might look like in the future, nor to freeze the future exploitation and utilization of the waters of the Silala by either state. To conclude, recognition that the current use of the waters of the Silala is consistent with the principle of equitable and reasonable utilization will ensure legal certainty and predictability in the relations between Bolivia and Chile. It seeks to prevent Bolivia from yet again changing positions on the applicable law to this international watercourse. Furthermore, during its pleadings, Bolivia felt it necessary to reassert that, I quote, it enjoys powers to use the waters of the Silala and regulate that use. Now, Chile has never questioned such sovereign right of Bolivia to do so. However, this sovereign power of Bolivia has to be exercised pursuant to customary international law, taking account inter alia the principle of equitable and reasonable utilization, the obligations to exchange information, and provide prior notification. This isn't a condition set by Chile. This is just a respect of the rules of law. Bolivia also attempts to reduce the weight of the principle of equitable and reasonable use in the instant case by underscoring its general aspects and arguing that Chile didn't explain its practical application. According to Bolivia, the principle of equitable and reasonable utilization is but, I quote, a very general guideline aimed at guiding the parties' conduct without imposing upon them any precise obligations of result. The general character of the principle of equitable and reasonable utilization as adduced by Bolivia in no way reduces its relevance in the instant case. In a bilateral dispute relative to the utilizations of a watercourse, that's the Gabčíkova-Nagymaros project case, your court didn't hesitate to apply the principle of equitable and reasonable utilization in the relations between the two parties to the dispute. Your court, in that case, applied this principle with respect to both current and future uses. Unlike what Bolivia asserts, this principle must thus obtain in the present case. The pulp mills on the River Uruguay case shows that the principle of equitable and reasonable utilization allows, I quote, sustainable development which takes account of the need to safeguard the continued conservation of the river environment and the rights of economic development of the riparian states. That's an end of quotation. This should form the basis for building relations between Chile and Bolivia, consistent with international law. The application of the principle of equitable and reasonable utilization goes hand in hand with other principles, such as those relative to the exchange of information, prior notification, and carrying out an environmental impact study. Bolivia portrays Chile's claims in matters of information exchange and prior notification as excessive. I'm quoting Chile in Bolivia here. Unjustified by the applicable law. It's also been claimed that Bolivia's projected usage of the waters of the Silala would not lead to any risk for Chile of significant transboundary harm, and that these activities, I quote, do not require an environmental impact assessment to be prepared or notification or consultation with other states. Bolivia's assertion whereby Chile, I quote, cannot point to a single instance in which Bolivia would have interfered with Chile's use of those waters or caused the slightest transboundary harm to Chile. That assertion can't be used by Bolivia as a loophole to justify its non-compliance with its obligations regarding exchange of information and prior notification. The fact that Bolivia has allegedly complied with this obligation to not cause significant harm does not signify that Bolivia has ipso facto complied with the principles relative to the exchange of information, prior notification, and to the carrying out of an environmental impact study. Not content with merely setting these obligations to one side, Bolivia would like to change their contents. Chile would like to point out that Bolivia's position is ambiguous, to say the least. On the one side, they recognize the customary value of the general obligation to cooperate, reflected in Article 8 of the 1997 UN Convention. And on the other, they deny the application of those principles codified in Articles 11 and 12 of the selfsame convention. Yet these Articles 11 and 12 are the realizations of the general obligation to cooperate. So, how can Bolivia comply with its general obligation to cooperate without providing the slightest information on its use of the waters of the Silala? Your court has recognized, I quote you, that it is by cooperating that states concerned can jointly manage the risks of damage to the environment that might be created by the plans by one or the other of them, so as to prevent the damage in question. The absence of any reply by Bolivia to Chile's request for information expressed no willingness by Bolivia to cooperate and put to naught those obligations in respect of information exchange and notification. Bolivia also mischievously alleges that Chile assigned customary value to all the provisions of the 1997 Convention and made no distinction regarding the obligations contained in Articles 11 and 12 of the Convention. Yet, the written pleadings of Chile make this distinction abundantly clear. Allow me to give a few indications on the contents of these two articles. The International Law Commission clarified with respect to Article 11 that the obligation to provide information on planned measures is intended to inform international watercourse states of, I quote, all potential effects of planned measures, whether adverse or beneficial. End of quotation. The ILC adds that such exchange of information, I quote, avoids problems inherent in unilateral assessments of the actual nature of such effects. End of quote. Article 11 of the Convention does set out a general obligation for riparian states to communicate the ones with the others. Bolivia, however, refuses to accept this obligation, asserting that, I quote them, the activities in question are insignificant, and, to quote again, there was absolutely no risk of significant harm or any harm, end of quote. Now, implementing the obligation to exchange information concerning planned measures is not linked to a risk of harm. It's an application of the general obligation to cooperate and of the duty of due diligence in matters of environmental protection. Regarding Article 12 of the 1997 UN Convention, let us point out, to start with, that its wording differs from that of Article 7 of the Convention, which relates about not causing significant harm. As the ILC indicated, I quote them here, the threshold established by this standard is intended to be lower than that of significant harm under Article 7. A negative effect may not reach the threshold of Article 7. And the Commission specifies that significant harm is not the criterion intended to trigger Article 12 of the Convention. And the Commission adds that the criterion of significant adverse effects provided under Article 12 enables the state planning measures to avoid admission that a planned measure risks causing significant harm within the meaning of Article 7. In the context of the instant case, Bolivia repeats willy-nilly that Chile has pointed out no harm that Bolivia might have caused to the waters of Silala because its activities around the river were very few and extremely moderate. That's a quote, and that, I quote again, none of Bolivia's very limited activities have ever given rise to risk of transboundary harm. End of quotation. However, as we've just seen, under customary international law, the fact that Bolivia hasn't caused significant harm or risk thereof to Chile does not excuse it from its obligations of information exchange and notification regarding planned measures. Bolivia may not unilaterally assess the risks of projects regarding water usage and then exchange no information with Chile in their regard. Let me point out once again that Bolivia at least once recognized its duty to transmit information and notification, and this regarding a response to a note from Chile about the Silala military post and the building of 10 houses. The obligations in terms of information exchange and prior notification allow harm to be prevented. Unlike what Bolivia asserts, Chile does not consider the principle of prevention as, I quote, a one-way street obligation. Both Bolivia and Chile are bound by the obligation of due diligence required under general international law. The importance of this obligation has been underscored by your court, and the court inter alia insisted on the fact that vigilance and prevention, which derive from the due diligence obligation on account of the often irreversible character of damage to the environment. The exchange of information and notification gives substance to the due diligence obligation. That's also the case regarding the carry-out of an environmental impact study. The nature, extent, and context of a project have to be taken into account. The ecological context of a project is indeed one of the considerations in an environmental impact assessment. Madam President, distinguished members of the Court, those conditions of aridity particular to the region where the Silala's waters flow should lead the parties to implement those obligations which fall to them both. Bolivia, however, attempts to reduce the importance of the contents of customary international law by recalling the role played by general international law in the management and protection of international watercourses. Your court will ensure equality of rights between riparian states and contribute to the establishment of stability and predictability. The position of Bolivia, whereby international customary law applicable to international watercourses is nothing but, I quote, a rather loose mesh of common rules, endangers legal certainty in relations between riparian states. Numerous international watercourses are not regulated by treaties, or only partially so. In such situations, customary law principles assuredly play an important role in the management and protection of international watercourses, as your court has stated on many an occasion. Madam President, distinguished members of the court, thank you for your kind attention. And I would request you, Madam President, to now give the floor to Ms. Jimena Fuentes Torrijos, agent of the Republic of Chile.
I thank Professor Poisson de Chazor for her statement, and I shall now give the floor to the agent of Chile, Her Excellency Ms. Jimena Fuentes Torrijos. You have the floor, Your Excellency.
Madam President, distinguished members of the Court, it is an honor to appear again before you to close Chile's second round of oral argument. It is plain that, in response to Chile's claims, Bolivia has tried to muddy the waters in this case. That may seem consistent with the subject matter of the dispute, but it is still nothing more than a classic defensive strategy. The dispute concerns the legal status of the waters of the Silala River system, the right of Chile to the equitable and reasonable utilization of this shared watercourse, as well as the substantive and procedural obligations involved with planned measures and activities that may affect the waters of the Silala or Chile's utilization of this international watercourse. Bolivia has no coherent legal answer to the issues raised. Bolivia claimed that the Silala was not an international watercourse. After having abandoned its original position, Bolivia asserted exclusive sovereign rights over a portion of the waters of the Silala, seeking to exclude the alleged 11 to 33% of the so-called artificial flow from the scope of application of the rule of equitable and reasonable utilization. It is now in full retreat from that position, maintaining the broad outlines of its defenses and counterclaims, but with the interior legal argument abandoned. As to the right of Bolivia to the equitable and reasonable use of the waters of the Silala River system, this Chile has never put into question. As explained by my colleagues, the dispute that divides the parties and that the court has been called to decide has developed since the end of the 1990s up to now. Yet, Mr. Furtó has described Chile's decision to go to the court as premature. He downplayed Chile's reasons to come before the court, pointing to the fact that Chile has continued to receive the waters of the Silala. Mr. Furtó also asserted that Chile has put too much weight on declarations of the authorities of Bolivia regarding the status of the waters of the Silala that were merely political in nature, devoid of any legal effects. And he also made the remarkable statement that these premature proceedings, as he describes them, might pose a risk to aggravate the tensions between the two states. The fact that Chile has come before the court in search of a decision that resolves a dispute with its neighbor Bolivia cannot conceivably be seen as hostile or unfriendly. In this connection, I recall that General Assembly Resolution 3283 on peaceful settlement of international disputes clearly states that, and I quote, recourse to peaceful settlement of international disputes shall in no way constitute an unfriendly act between states. Madam President, members of the Court, Chile has come before the Court because it has proven to be impossible to bring an end to the dispute through an agreed settlement. This is not the first time that Chile and Bolivia have had contradictory views on the utilization of international watercourses. In the specific context of Chile-Bolivian relations, this kind of dispute has a demonstrated potential for aggravation, and therefore a judgment by the International Court of Justice should be welcomed, not avoided or minimized, as Bolivia seems to desire. To take an example that is not before the Court, there is another long-standing dispute between Chile and Bolivia over the Lauca River, where Chile is the upstream and Bolivia the downstream state. The Lauca is another shared watercourse as to which both Chile and Bolivia have the right to its equitable and reasonable use. However, in 1962, Bolivia claimed that Chile was prevented from using the Lauca's waters without Bolivia's prior authorization. As Chile proceeded with its plans to use a portion of the waters of the Lauca River, in April 1962, Bolivia broke diplomatic relations with Chile and asked for an urgent meeting of the Organization of American States Council, charging Chile with an act of aggression against its territorial integrity that, in its view, threatened the maintenance of peace in the American continent and triggered the application of Article 6 of the Inter-American Treaty of Reciprocal Assistance. Diplomatic relations between Chile and Bolivia have not been restored since then, except for a short period between 1975 and 1978. With respect, it appears infinitely preferable that the resolution of at least the dispute over the Silala River be achieved through peaceful settlement before this court, as it now will be. Indeed, Chile and Bolivia share more than 16 watercourses and a number of transboundary aquifers. Each of these transboundary shared water resources is located in the extremely arid Atacama Desert. Sometimes Chile is the downstream state, and sometimes Bolivia. While it may be obvious that Chile and Bolivia should cooperate with regard to their shared water resources, unfortunately, cooperation has not been easy. Indeed, it is very difficult to talk about shared water resources when one of the parties, as is the case with Bolivia, has contended that as the upstream state, it is entitled to exclusive sovereign rights over some or all of the waters of the Silala River, and as the downstream state claims a right of veto over upstream uses of the Lauca River. Taking into consideration the difficult reality of Chile-Bolivia relations, it is regrettable that Bolivia does not appreciate the importance of a declaratory judgment from the court that will resolve this dispute regarding the status of the Silala as an international watercourse and the rights and obligations that follow therefrom. When interpreting its judgment number 7 in the choice of factory case, the Permanent Court of International Justice emphasized the role of a declaratory judgment in the resolution of international disputes by stating that its intention is to ensure recognition of a situation at law, once and for all, and with binding force as between the parties, so that the legal position thus established cannot again be called in question insofar as the legal effects ensuing therefrom are concerned, close quotation. And of course, it is clear that the parties have been unable to resolve the Silala River dispute without the court's assistance, even if, during the course of these proceedings, Chile made a last attempt to reach an agreed settlement with Bolivia. As to this, during my opening speech in these oral hearings, I noted that in June 2019, Chile proposed the terms of a settlement, but it received no reply from Bolivia. Nonetheless, and we consider it important that the court appreciate this, the 2019 Chilean proposal was nothing if not very balanced and reasonable. It reflected the fact that during these proceedings, Bolivia had largely considered that the Silala is an international watercourse and had abandoned the so-called historic debt claim. Moreover, it had been agreed that all the waters of the Silala, whether as groundwater or as surface water, flow down the gradient to Chile. By letter addressed to the registrar, dated 5 April 2022, Chile asked the court permission to submit the text of the 2019 Chilean proposal. In accordance with Article 56 of the rules of the court, and having received the consent of Bolivia, the court granted such permission. The terms of the proposal that Chile submitted for the consideration of Bolivia were the following. To begin with, the preamble states, open quotations, both parties recognize that the Silala is an international watercourse shared between Bolivia and Chile, which waters, both subsurface and surface, are governed by customary international law, and in particular by the rule according to which both riparian states are entitled to an equitable and reasonable utilization of its waters and the obligation to prevent the causing of significant harm to other riparian states. This is the second paragraph of the preamble. Accordingly, paragraph 2 states that, open quotations, both Bolivia and Chile are entitled to the equitable and reasonable use of the waters of the Silala River system in accordance with customary international law. On its part, paragraph 3 states that Chile's current use of the waters of the Silala River is in accordance with the principle of equitable and reasonable utilization. Then, paragraph 4b refers to Bolivia's prospective uses in the following terms. If in the future Bolivia plans to initiate new uses of the waters of the Silala River, these shall be assessed in order to prevent any significant harm to Chile, and together with other relevant factors, Chile's existing uses of these waters within its territory should be taken into account. Likewise, the parties shall comply with the obligation to exchange information and to consult with the other party, as well as with the obligation of cooperation between both states. All that is entirely consistent with the customary principles reflected in the 1997 UN Convention. Finally, paragraph 5 of the proposed agreement refers to the channelization in Bolivian territory, and it reads, Bolivia has sovereignty over the channels and drainage mechanisms in the Silala that are located in its territory and has the right to decide regarding its maintenance, insofar as in the exercise of its sovereignty, it complies with its international obligations regarding the Silala River system as an international watercourse. In particular, Bolivia will inform and consult with Chile regarding any planned measures for the dismantling of the channels and drainage mechanisms and/or the restoration of the wetlands in its territory, and shall take all the necessary measures to prevent any significant harm to Chile in the execution of those works. I also ask the Court to read in due course the letter accompanying the proposed agreement to see if that was in any way unreasonable, as was being suggested last week. Of course it was not. And the key point for now, as the Court knows, is that Bolivia never responded. So there has inevitably been this hearing, and inevitably the Court must now determine all the issues in dispute. The dispute is now before the Court, and a judgment is necessary to resolve the dispute between the parties about the status and use of the waters of the Silala River. Chile welcomes the judgment of the Court. With this, I conclude the second round of oral pleadings by the Republic of Chile. In accordance with Article 60, paragraph 2 of the Rules of Court, I will now read the final submissions of the Republic of Chile, the signed text of which I have submitted to the Court. Chile therefore requests the Court to adjudge and declare that A. The Silala River system, together with the subterranean portions of its system, is an international watercourse, the use of which is governed by customary international law. B. Chile is entitled to the equitable and reasonable utilization of the waters of the Silala River system in accordance with customary international law. C. Under the standard of equitable and reasonable utilization, Chile is entitled to its current use of the waters of the Silala River. D. Bolivia has an obligation to take all appropriate measures to prevent and control pollution and other forms of harm to Chile resulting from its activities in the vicinity of the Silala River. E. Bolivia has an obligation to cooperate and to provide Chile with timely notification of planned measures which may have an adverse effect on shared water resources, to exchange data and information, and to conduct, where appropriate, an environmental impact assessment in order to enable Chile to evaluate the possible effects of such planned measures. Obligations that Bolivia has breached so far as concerns its obligation to notify and consult Chile with respect to activities that may affect the waters of the Silala River or the utilization thereof by Chile. Thank you for your kind attention.
I thank Your Excellency. The Court takes note of the final submissions that you have just read on behalf of Chile in relation to its own claims. Your statement brings to an end Chile's second round of oral argument on its own claims. I recall that on Wednesday, 13 April, between 3 p.m. and 6 p.m., Bolivia will present its second round of oral argument, including counterclaims, and that on Thursday, 14 April 2022, between 3 p.m. and 4 p.m., Chile will present its reply to the counterclaims of Bolivia. The sitting is adjourned.